and thanks for having me. I am a child in the school district, so it's nice to be here in this community. And just to tell you a little bit about myself, I'm a partner in a local law firm in Mount Kisco. I used to be a chair of the Westchester County Bar Association's Guardianship Committee. And I'll be talking about the different flavors of guardianship, because we're all at risk of our own guardianship if we don't do certain advanced planning. That most of the people are focused on children, and especially whether a child might need a guardian. So I sort of explained the difference and how to avoid it where it's avoidable. But that was my committee work in guardianship. And then I also serve on the executive committee of our state bar association. So there's an American Bar Association, but New York State has its own bar association that supports lawyers in different practice areas. I've been practicing almost 25 years, but the first 10 years of my practice, I did general litigation of a commercial nature, some antitrust law, and then ended that chapter at Reader's Digest in-house when it was still located in Chappaqua. And I worked in that big red brick building and did advertising compliance. And then 9/11 came, and I thought, why am I doing advertising compliance? And it was just a real kind of shift of why did I go to law school, and I learned of a program in surrogates court where lawyers could be appointed to represent people who couldn't represent their own interest. It's called a guardian ad litem. And that kind of began my journey in this, and the State Bar Association really supported me as I retrained from a commercial lawyer to a trust and estates lawyer. So my give back is I serve on the executive committee and train lawyers who are looking to make that same transition. And what's nice about being on the executive committee is you really learn about things as they are percolating through Albany. We lobby in Albany to stop the percolation when the percolation is going in the wrong direction. So when they're looking to underfund or defund certain programs through our Medicaid program, which is half state supported, half federally supported, we do a lot of advocacy surrounding that. And education, because once the lawmakers hear what the impact of that will be, they are people too, and they've been very responsive to our lobbying efforts. All right, and then I'm a certified elder law attorney, but elder law really is about special needs planning, and we're in the process of rebranding. So you can see our State Bar Committee is elder law and special needs planning. The designation created in the 90s is still called a certified elder law attorney, but it's really about a certification in terms of a knowledge set relating to government benefits and trust planning and issues surrounding that. I'm from California, so I'm a New York transplant. I still really miss California, but that's how I came to be in Berkeley and then came east for Rutgers. And then, because of our tri-state area, I just got licensing in all 3 jurisdictions. So I went to school in New Jersey, moved pretty shortly to New York, and then because we're so close to Fairfield, I sat for the Connecticut bar. So Connecticut is actually the bane of my existence. I didn't pay my licensing fees for a few years, and that counts as a suspension of your license. So don't be scared if you ever see my license suspended. I think I had 3 children under 5 at the time, and I just ignored all these warning letters. Okay, so this can't be considered legal advice. If in our office we give 1-hour complimentary consultation. So if you have a particular situation, please take advantage of that. Feel free, though, to ask questions of a general nature, and I'll stop you if I can tell it's getting too personal and is more like a consult question than a general audience recorded for the Chappaqua School District type of question, okay? So we just want to maintain attorney-client privilege. All right, so welcome to the overwhelming intersection of law and regulation that's applicable here. And this isn't meant to give you a panic attack, but it is meant to give you some support in understanding why this is not easily accessible. Like, you are struggling because it is a struggle. It's a struggle of balancing Social Security law, Department of Health regs, the Internal Revenue Code, the state's powers and trust law, which is our New York statute governing trusts, the Surrogates Court Procedure Act, which is our New York statute governing, in part, guardianship of persons with intellectual disabilities, the General Obligations Law, which governs powers of attorney, and the Mental Hygiene Law, which governs, at least in part, an adult guardianship proceeding known as Article 81. So that's the medley and overlay. And Lucille and I had looked at this study last year, and I kept it in, but it was a really interesting study of the parents of a child with intellectual developmental disabilities. And you can see, you know, some had located a knowledgeable attorney. Some had discussed a future plan with family members. Over half had discussed that same plan with the child, which I was impressed in part by. But under half, think about this is kind of scary, under half had identified a successor to the current caregiver. As I go through the other slides, I'm going to come back to that idea because that really becomes a crisis when there's not identified standby guardian of some sort. It leaves people in the community wholly unable to develop their own care plan, and then that can turn into an emergency guardianship proceeding. All right, then establish powers of attorney and healthcare proxies for the caregivers, under half. And so this is like, of all of them, and establish a special needs trust. These are your two easy fixes. Like, and so I'll talk about how to protect yourselves, and by protecting yourselves, protecting your children. Established guardianship is at 40%, and then the residential plans, there's 3 different categories for it. They're all anywhere from 23 to 30% in terms of where parents are on the spectrum of residential planning. That's a little bit like blaming the victim because there aren't that many residential opportunities available, and I think that's part of that lower statistical level there. And then creating a letter of intent, and that again is low-hanging fruit. Like there are the things that you can identify in here that are easy to do, the things that are harder, and there's some institutional barriers too, and kind of plan from there and prioritize. So I'm going to define the estate planning and trust options because that is the low-hanging fruit. Discuss guardianship laws. Again, those are very achievable things. And then provide some information on government programs and community resources. All right, Lucille, you liked this phrase last year, but it's planners win. And I say here that it's somewhat unfair. And it really is. It's, you know, having the educational background to sit in the room, subject yourself to this kind of lecture, gather information, do the research, and then act on it. And that rewards a certain parent set. But it's absolutely a truism, and what you can do in advance will save a lot of costs later on that happen on a more crisis emergency basis. So the coordinated plan is really needed first and foremost for the parents. You need to have people who can stand in your shoes if anything happens to you. And that starts with you and looking at your own documents. And then you can build from there to protecting a child who needs additional supports. And then you can open a conversation with any other family members who may be directing support toward that child, especially grandparents. I can't tell you how many grandparents I work with who that's super top of mind for them when they come in. It's usually like equal shares for all of the children, but I have a grandchild with special needs and I want to make something, you know, do something special for that child. So the documents that the parents need, at a minimum, a will, a trust for the child, power of attorney, and healthcare advance directives. These documents help avoid guardianship for the parents. So I'm going to say I probably have 40 guardianship cases a year at my firm. And that 35 of them are for adults who have lost capacity. Okay? And I don't have the macro stats on guardianships for people who've lost capacity versus guardianships for people who under the law would be considered to never have had capacity. But my guess is that that's probably 95% of guardianships are people who have lost capacity and didn't sign advance directives. So imagine you're in the hospital, you're in a coma, you need someone to do healthcare planning and discharge planning, health insurance billing, file your income tax returns, pay your mortgage. That all comes from a power of attorney and healthcare advance directives. People often think that's going to come from a will, that the nominated executor in the will can then start to act. But wills are just a piece of paper until someone passes away and a judge declares it to be a valid last will and testament. The first time I went to surrogate's court with my naivete, I came with a will and all the other court petition documents to support a probate petition in court, but I didn't have the original death certificate for filing, and they wouldn't take anything until I showed them the original death certificate. So that's when they have standing to take on a will. So even if you think your will is going to be contested by family members and you want to have it done ahead of time when you're alive, never be determined and adjudicated out ahead of time. And that's because you can amend or revoke it at any time. A will can always be changed. So the moment it can't be changed is when you've passed away, and that's when the court deems it ready to be considered for its review. So you need other legal documents besides a will. So people often come to me to do a will. I say, that's great, we're going to do a will. We're also going to do a power of attorney and healthcare documents. And then you have to coordinate your assets with that set of documents. So many of our assets pass outside of a will that if you create a trust inside a will, or a separate trust for the benefit of a child with special needs, because you think a grandparent might fund it, so you want this kind of freestanding special needs trust, you need to then look at your retirement account designations, your life insurance designations, and point those designations toward these trusts that you are creating. Otherwise, if you just say in those designations, to my spouse, and if not my spouse, and to my children in equal shares, that's not going to utilize the really beautiful trust that we've created that's not going to make a child ineligible for government assistance. So it's a coordinated plan. We create the structure first, then we look at what our clients own and how they own it, and we make it all sync up. And then help with a letter of intent, and then also make some recommendations to the financial advising piece of it. We don't do financial advising ourselves, but we can certainly make some recommendations even on the type of advisors to seek advice from. Okay. So this is just a visual of those documents and when they are applicable. So a power of attorney is applicable the moment you sign it. A healthcare proxy is applicable the moment you can't make your own healthcare decisions yourselves. You can still communicate with your doctors. They're not going to work with a proxy. They're going to work with you. Trust, if you create a living trust, it's applicable when you sign it, and then it continues to become applicable. It doesn't automatically get extinguished upon your death, whereas these documents are extinguished upon death. They're based on this principal-agency relationship that requires the principal to be alive for the agent to have authority. So that's where wills then start to pick up where the power of attorney left off and the executor position. So these are agents. This is an executor. This has trustees and successor trustees. And parents can be their own trustees. You can create a special needs trust for a child. Be the trustees while you are both alive, and then name successors later on. So that power of attorney is going to cover everything not health related. And if you want to give yourself homework, you can pull out your estate planning folder when you get home. If your power of attorney is 2 pages long, or not in the folder that holds your will, like you just didn't do it, then that's your homework. Our power of attorney is 11 pages long. We have to follow a statutory form, but the state allows us in a few different sections to modify it. So that's where we put in all the extra stuff that the state doesn't give you. Really important in our powers of attorney, even though it seems scary, is we have to give our agent the ability to give our assets away. And that's really used to be done more for tax planning. It's much more done now for special needs planning for ourselves. So if I have a critical event, I have a stroke and I need 24-hour care, I would need my spouse to stand in my shoes, take all the assets out of my name so I could qualify for Medicaid 24-hour home care through our community Medicaid program. So I inherit a lot of powers of attorney that have no gifting powers, or have gifting powers of $500 a year, or $12,000 a year. And that's, if the person doesn't have capacity, that's a guardianship proceeding. To go to guardianship court and ask permission to gift in order to qualify for Medicaid. So instead of being able to go straight to Medicaid eligibility, we have to do a diversion in court to get the authority to even do the Medicaid plan. So that's what I'm talking about in terms of just doing your own base layer of planning in case life goes sideways for us. And then we have the Healthcare Advance Directive. We're New York. We have many more documents than most jurisdictions. New Jersey and Connecticut combine these in one document. But we have a healthcare proxy and a separate living will. My clients call the living will the pull the plug document. It's essentially meant in New York to be an expression of your end-of-life preferences for treatment or non-treatment. The way we draft these is we give the healthcare proxy final say, so that the person who you trust and have named to make these decisions will never be obligated to continue to stop treatment if they feel there's still some other treatment option available. So we really rest the final authority of the healthcare proxy. But this is just meant to be, under New York law, clear and convincing evidence that you wouldn't want to receive treatment if you were in an end-of-life situation with no chance of recovery. These are not actual doctor's orders, though. And so people will say to me, you know, I need the DNR that you helped put in place for my family member. And I'll say, no, we put in place a living will that allows you now to work with the doctor to put in a DNR. So DNRs are doctor's orders. They're nothing that you can do on your own. You have to do it as a patient with your doctor or as the patient's representative with the doctor. And DNRs are used in hospitals. We have non-hospital DNRs that are, it's a misnomer what the document is called. It's a MOLST form, if you've ever heard that acronym. But it's called a medical order for life-sustaining treatment. But within it is a box you check with your physician and co-sign with your physician to say, I don't want treatment. Really important, if you ever know anyone in the community who wouldn't want treatment, they need a MOLST form, or else if 911 is called, the paramedics have to give treatment until you get to the hospital. So they're legally obligated to treat unless they see a MOLST form in the house. And then I explain wills are only effective upon death. They name the beneficiaries of your estate, and they nominate fiduciaries. The fiduciaries come in three flavors. We have executors who are in charge of collecting assets and paying them out in accordance with the will and the law. We have trustees, potentially, if we are creating a trust inside the will. And then we have guardians for minors. And that's where we nominate guardianship there. And I'll talk more from a special needs planning perspective. That nomination, if you had a child with special needs, you wouldn't want to rely on that, which is why I say guardians for minors in that section, because you want to do extra planning for guardianship so that there's seamless guardianship. It takes a good 3 months to probate a will. So if you have a child with special needs, you don't want to wait for that process. You want to have something in place already. I'll talk about what that is. And I hinted at this. There are certain assets that are going to be governed by a will. They are assets that are titled solely to the decedent with no designated beneficiary and no joint with rights of survivorship or payable on death designation. So if I own a house and the house is titled just to me, or if I own it with my sister and we own it as tenants in common, then my half of that house with my sister is governed by my will. Tangible personal property, I like using TJ Maxx. Those rugs and clothes and purses and luggage. That's your tangible personal property. If that's all that needs to pass under a will, we don't usually bother probating the will. The family just collects the tangibles on their own unless they're really high value. Business interests. LLCs, traditional corporation, a partnership, those sorts of company-based interests are also governed and will pass by will. But here are all the assets that aren't governed by a will. Retirement accounts are set up to have designated beneficiaries. They're opened that way because our tax code is better if a beneficiary, a specific person or qualifying trust is named. So the financial institutions incorporate that into the account opening process. Annuities and life insurance, they are contracts, and the contracts are structured so that within the contract you name the beneficiary upon death. All of these are subject to being changed though, so we can collect change of beneficiary forms with our clients, help them change the beneficiaries to coordinate with the trust planning that we end up doing.
Is there a time period on that? Like, say you set them up a while ago, is there a time period you do that in to put it in a trust, or not really?
There's no, you, as long as you own it, you always have the right to control who receives it and to change who receives it on death, with the only qualifier to be that any federal retirement program that's ERISA based, if you're married, you have to have your spouse's consent to not name your spouse as the primary 100% beneficiary. But otherwise, the account owner can control it. The time period or pressure is really just more that you want to make sure whether you have minor beneficiaries or a child with special needs that points to a trust and not directly to that child. And even for any children who don't present with special needs, 18 is the legal age when they can receive assets, but I have a 16-year-old, 19-year-old, and 21-year-old. I can tell you that they are not ready to manage the portfolio of assets that would be available to them if my husband and I died in a joint accident. So we can change those age markers and adjust them upward. The most common structure utilized is 25, 30, 35. So they receive a third at 25, half at 30, remainder at 35. We have family members in charge of the money in that interim period who can use it, but we're using their judgment and not the kids in that interim period. Okay. The other class of non-probate assets that aren't going to be governed by will are joint with rights of survivorship and real estate that's jointly owned in some sort of mechanism, and trust assets. So anything that you transfer to trust while you are alive is now governed by the trust agreement and not the will. And so that begs the question of, like, what is a trust? Fundamentally, a trust is a relationship. It's a relationship among the person creating it, the grantor, the person managing it, the trustee, the person benefiting from it, beneficiary, and they can be different beneficiaries at different stages. You could create it for one person, then provide on that person's death who the money goes to. And then the corpus. So every trust has to have those four things to come into being. And they can be created inside wills, and they can be created while we are alive. And trusts that are created while we are alive are either called living trusts or inter vivos trusts. And so there are special needs trusts that have developed as a way of preserving government eligibility in means test programs like Medicaid and SSI, while still creating a pocket of money that can pay for everything that those government benefit programs aren't going to pay for. They are sometimes referred to as supplemental needs trusts. And those terms are really interchangeable. It's not, it's 6 of one, half dozen of another, whether between special needs versus supplemental needs trust. But here's the catch, and this is how the planners win, going back to that concept. There are third-party special needs trusts, and first-party trusts, and hold trusts. And you're going to potentially be encountering and developing and needing to utilize, at a minimum, the third-party trusts and the pooled trusts most likely at some point. But you can hope to avoid the first-party trusts. There are truly some circumstances where they're unavoidable. But let me go through the differences. A third-party SNT, as the name implies, is a trust created by any individual other than the beneficiary. And because it wasn't the beneficiary's money that went into that trust, you have a lot more flexibility under government programs about the terms of that trust. We can have multiple beneficiaries of it, even if we want. We can provide for extra payments to caregivers supporting the beneficiary. We can make sure that whatever is remaining on the beneficiary's death goes to our family members and not back to the government. That's the beauty of a third-party S&T and why planners win. You get to create your own special rules for this pocket of money while still preserving government assistance eligibility and meeting those requirements for the beneficiary. They can't look at this pocket of money in terms of determining eligibility. They can't control what the trustees are doing with it. Whereas with first-party money, when we get to that, you'll see it's a lot different. There's a lot more strings attached to it. Here is the biggest takeaway. Like, just red flag this, okay? You cannot fund an S&T for a person you have a legal duty to support. If anyone's married here, you can never create an S&T ever for a spouse until you die. So my S&Ts for a spouse have to be created in a will. It's the only place in New York I'm allowed to do that for a spouse because our duty to support a spouse dies with us. But for children in New York, we have a legal duty to support them until the age of 21. So as parents, we can create a structure of a third-party S&T. We cannot fund it until the child's 21st birthday. But you want to create the structure in case anything happens to you or the other parent. And then also, there might be grandparents who want to point money to it. So you're allowed to create a trust, and other people can put money in that trust. But you can't put money in that trust until the child is at least 21. And I have to clean up some of these issues that walk into my office sometimes where I have commingled money. I have money that was deposited when the child was 10 and 11 and 12 and 25 and 26 and 27. So you just want to have really clear baskets of money, and if you ever do end up with both a third-party trust and a first-party trust for different reasons, you've just got to preserve the sanctity of each of those so that you don't think, oh, it would just be easier to have one brokerage account. Because it can end up tainting the whole.
What if one parent dies before the child's 21 and that parent has assets in there that they want to go to trust upon death?
That's okay.
Is that okay? Because
that's
that person
okay.
died, but the husband
exactly.
didn't, or the wife didn't?
No, because that's exactly. The trust can be created inside a will, and it can also be created outside of a will. I like to keep things really easy for the families I work with and as economical as possible. So if grandparents are off the table, not in a position in any way to direct money, and the parents have no intention of putting their own money in the special needs trust until the death of the second parent, then I'm generally recommending we build in the special needs trust into the wills, knowing generally that joint accidents are a very rare occurrence, and that I can work with the surviving spouse at that time when we have more information about what type of trust can be created outside of a will. But I don't want to layer on too many legal instruments when I know that we might have a decade or 2 or 3 or 4 before funding is actually going to occur. So why create something irrevocable now that may not work in 10 years and we just have to throw that out and start fresh? So if something isn't going to be funded or at risk of being funded in the near term, I'm going to create that trust inside the parent's wills. But if I'm working with a parent who is either widowed or divorced and the funding risk is on the death of one person, I want a separate special needs trust for that client, because separate trusts created outside of wills have less court supervision on an ongoing basis, and court supervision is expensive. And I'll just give you one example of that. If I create a living trust and I'm the grantor, I have an article in my trust agreement that says who the trustee is, and the trustee's authority came from me. And that article of the trust agreement says, typically in our agreements, a trustee may resign at any time on 30 days written notice. And if that happens, the next trustee is X. The trustee after that is Y. The trustee after that is Z. And if no one is named, then, you know, certain people get to select the trustee. And when one of those events occurs, all of that trustee authority happens without having to go to court for ask permission of any of them. But everything within a will, the authority emanates from a judge. So even if the will says the first trustee is X, the second Y, the third Z, when X can no longer serve, X has to apply to the court to resign and ask permission. And then Y has to ask the court to be appointed. And letters of trusteeship have to issue from your local surrogates court. I have 3 petitions right now for successor trusteeship. And when I explain this to clients, they think I'm lying to them. And I'm creating a legal project that I'm like, I swear I'm not making this up. This is actually required. You have no authority until the judge gives you letters of trusteeship. But it's petition-based work, and once you have to file a petition in surrogates court and get jurisdiction over people, it just turns into like I'd say a $10,000 legal project for something that's like written on the face of a will. So in general, I don't want to put people in trust structures too soon, but I also ultimately want people in trust structures that aren't created inside wills. All right, so in terms of funding a trust, cash can go in it, non-retirement investment accounts, life insurance, real estate, and even retirement accounts. If you do point a retirement account toward a trust, though, very important to work with, with an attorney to make sure the trust has the right terms in order to delay when that retirement account is going to be income taxed to the trust. In general, our estate tax exemptions are really high. We right now can pass 5.4 million estate tax-free as New York residents. If we go over it, we lose it altogether. It's a problem New York has. But if you're under 5.4 million in assets, or 10.8 as a married couple, you're in a really good stead to not have an estate tax problem. But let's say you have a $1 million retirement account. If it never experienced income taxation while you were alive, the beneficiaries still owe income taxes on it. And so when you name a trust as a beneficiary, it could trigger income tax in 5 years unless you have the right terms that allow you to stretch the income taxation over the actual life expectancy of the beneficiary. So just know there's always special rules with retirement accounts to be aware of. I've been a little more expansive in the beneficiaries of the SOTs. We work with families who have multiple children, and not all of them present with special needs. But that doesn't mean that we can't make all of the children a beneficiary of this trust and allow the trustee to sprinkle support among all of the children. And we can put language in that says that the trust, the purpose of the trust, the primary purpose is to support child X, but a permissible use of the money is also to support childs Y and Z. And it allows a little bit more flexibility and just a responsiveness to how life may be developing. And then contingent beneficiaries are typically the other children or other family members, or some sort of charity. We've done a lot of charitable work, charitable remainder beneficiaries, especially if there's a particular community organization that the family feels indebted to. All right, so the trustees are typically using this pot of money to pay for everything that the government assistance programs won't pay for. But let's say that they think it's inadequate. We can build in language that says that the trustee can even use the money in a way that makes the beneficiary ineligible for a program if, in the trustee's judgment, it would be a better support of the individual. So again, just an example of how much flexibility we have here. Here is the biggest problem, and I actually met with a client very recently about this, like yesterday. So he walked into my office, he's managing trust for a family member who receives Medicaid, and started to tell me about the weekly stipend he gives this family member. So cash is a no-no. You cannot give cash to a beneficiary. So if you ever manage, if you're ever a trustee of anyone's S&T, just be sure to get legal advice about what permissible distributions are. There's an amazing credit card run by TrueLink Financial, which allows trustees to give to the beneficiary a credit card with certain parameters surrounding the credit card, whether it's a spending limit or a type of purchase that is allowed or not allowed. I'm a trustee of a trust for a person who we recently obtained a TrueLink card for. He'd been missing for many years. And what we were able to do is prohibit transportation expenses. He needed to coordinate any travel expenses with us so that we could always find him. So just know cash is a no-no, and it's frustrating because it doesn't seem right. Like the trustee for this family member was like, doesn't he deserve to have spending money, like walking about money? And there's a certain level of walking about money you're allowed, but usually that's absorbed by SSI. So it's really small. It's around $700 to $800 a month that you're allowed to directly access if you're on Medicaid. Okay, you can pay for education and vocational training, vacations, and even family members accompany them on vacations, and professional services, layering on additional therapies, housing. There's a certain interplay with SSI you have to be aware of, where it might reduce some of the SSI cash payments if you pay for things such as food and shelter. But sometimes it's worth it to have better shelter. You lose a little bit of your SSI monthly cash stipend, but you have a better housing situation. So that's that trustee latitude that we're allowed to do. I hinted before, even for those family members who don't present with any special needs, you want to consider some trust planning as well. And in that 25, 30, 35 example I gave, so the 18-year-olds don't just automatically come into a pot of money. You can build in there trigger S&T provisions. God forbid a family member presents later on with a special need. You're allowed to then have it trigger into a special needs trust. So again, when you go home to do your homework, you pull out your estate planning folder. You want it to be thick, because the thicker it is, the more likely it is that some of these mechanisms are built into it. And don't be intimidated if you're working with a lawyer and you see a document, yay thick. You really want it to have all of these things, that even if you don't fully understand everything involved. And then the letter of intent is really a non-legal document. It's meant to be the caregiver's voice of what's worked and what hasn't worked and what your hopes and aspirations are. And it can be developed and a copy provided to the lawyer, and we can advise on some topics to cover, but it's really a personal family document.
I just want to share, I have a template that, and a couple years ago we did a parent session, and we all went to somebody's house with our laptops, and we went paragraph by paragraph, and everybody typed in their own to at least get the first draft done.
Oh,
but I could share with Liza, I could share with you the template, and you can put it on the web page. It was more fun to do in a group, just because it's like a lot of people don't want to think about these things. But everybody brought something to drink and something to eat. And we went through it all together, and a couple hours, everybody had a draft. So it was a good experience, a good session.
Oh, excellent. All right, so again, not legally binding, but invaluable to the plan. And these are different action items and things to cover. This is more of a financial slide. Generally, you can develop a great trust plan, but you also want to look at the sources for ultimate funding and support for a child, and work, closely with a financial advisor in that respect. Determine what the appropriate level of risk is, and then, again, in terms of putting the focus on the parent or grandparent who's the funding source, looking at their own asset risk for long-term care expenses, whether it's home care or nursing home care. We all kind of think, in our American society that has conditioned us this way, we have houses that really don't accommodate any kind of mobility issues. It's as if our houses are built as if none of us are going to age. And our thinking is that we live and then we die. We're all up here, we're in lectures like this, and we're doing great, and then we're dead. And it's much more of a gradual decline. And so with that in mind, Medicare is typically the insurance that most of my clients walk into my office with. But it's insufficient, which is why they are in my office, and we need to layer on Medicaid on top of Medicare to cover long-term care costs. So Medicare is like Aetna, United Healthcare, Blue Cross Blue Shield. It's traditional health insurance. If you have heart issues and need heart surgery, Medicare's awesome. If you have Parkinson's with cognitive decline, gait issues, ambulation issues, Medicare is not going to support you in that way, but Medicaid New York will, at least as it presents today. We have an incredible Medicaid program in New York. I said I was licensed in all 3 jurisdictions. Almost all my Medicaid applications are to New York, because my Jersey and Connecticut people have to move to New York to access the care that they actually need at home. So we both allow clients to protect income and assets and still receive home care. And we actually provide up to 24 hours of home care in our New York Medicaid program. So I think that's the biggest risk, is the unfunded risk of long-term care costs for parents that can wipe out their assets before death and leave nothing to fund an SNT. So you have to identify that. And there's some really interesting hybrid life insurance policies now that provide for a death benefit, but can also be utilized for long-term care costs. And so that's something to think of, kind of looking around the room at like our age and stage. For my clients who are in their 80s or 90s, they're not going to get through underwriting on that kind of product. Okay. My biggest recommendation to people as they enter into the financial market and are looking for advice is to try to find someone who works on a non-commission basis. So an asset under management model with a fiduciary responsibility. Those are registered investment advisors governed by the SEC. I generally want to see people stay off of the broker side of the page. They don't necessarily have a fiduciary duty to you, and their economic structure rewards the selling of product, and the selling of product like annuities leaves you less flexibility. They're contracts that penalize you if you try to cancel them, if you're even allowed to. So generally, work with someone who has a fiduciary responsibility to you. All right, so then we enter the world of first-party SNTs. This is the beneficiary's money. This is the beneficiary's money because a grandparent left a retirement account to that child, wanting to give them an extra pot of money rather than to the child's trust. Or malpractice was committed, and a lawsuit was brought on the child's behalf and a judgment obtained. So in the judgment, that is an unavoidable first-party SNT. That was the child's legal right and legal money. It could never have been anyone else's. And so fine, we have to live with a first-party SNT. At least we have an extra pot of money that we didn't know we were going to have before. But in the grandparent example, or substitute parent, or anyone else who could have pointed that money to a third-party trust, very frustrating to find yourself in the first-party set of rules. Because in the first-party set of rules, the state is watching that trust like a hawk because they get whatever is left on the beneficiary's death. and they get repaid and reimbursed for anything that they provided in support from the age of 55 or over. And so it depends how long a person lives, how meaningful that is, but most of the time we are writing checks for the entire remainder balance over to the county. All right, for a first-party SOT to be created, the individual has to be under the age of 65. This goes away as a planning option once someone is over 65. And the funds can only be used for the benefit of that person. Payback, and there are rules on who's allowed to establish it. So only certain people are allowed to establish it, and if those people don't have the legal capacity to do it, or are no longer living, like parents can do it, but if the parents are no longer living, you have to get a court-ordered first-party SNT. So sometimes it's created by individuals, sometimes by a court. You can't even pay for a funeral upon the death of a person. So one of the first things I tell people to do with first-party money is to pre-plan a funeral. Because once the person dies, it can no longer be spent at all except to pay it back to the state. If you satisfy the state's interest and for what they paid for that beneficiary, then you're allowed to pay the rest to the contingents. But typically the healthcare costs, the housing costs are so high, there's not much left. Okay. Also, if you're ever as a trustee going to spend more than 10% of the corpus, you have to ask for court permission because the state wants to know whether that's a valid expenditure and they want to scrutinize it. So the trustee is just really, again, being watched. All right, and then that brings us to pool trusts. Pool trusts are run by nonprofit companies in New York that have state charters. And they're really designed to protect various spend downs that may happen, and the spend downs usually relate to income. So income recurs every month. Every month you're over the allowable amount of income. But if you deposit it in a pool trust, you don't lose that excess income to Medicaid. So let's say Medicaid lets you keep $850 a month, but you have $1,850 SSDI payment. That extra $1,000 either has to go to Medicaid or to a pool trust. So better to put it in the pool trust and have the trustee there pay an expense for you. So the idea is the beneficiary gets to control $850 outright on their own. Anything in excess has to be managed, and the pool trust can only pay it out to a vendor. So again, no cash back to the beneficiary. And it has to be a vendor bill for the exclusive benefit of the person with special needs. Here's the catch though. You don't want money to accumulate there. It's why it's not a great option for asset planning. I don't like to use pool trust for asset planning. I want special needs trust for asset planning, because on the death of the person, the entire remaining balance, technically, it gets retained by the pool trust company, technically for the benefit of other disabled persons. But it's not like there's a replenishment of everyone else's accounts. It's more that it covers the overhead of the pool trust company and the employees running the different accounts. Okay, so let's turn to a child who presents with intellectual or developmental disabilities and the planning that they are legally allowed to do. And there's going to be a wide spectrum of what's permissible or not. So for a child who is high functioning, on their 18th birthday, they can work directly with a lawyer, talk about some advanced directives, and sign them. We get to presume legal capacity as long as we feel that a client understands the nature and consequences of what they are signing. We're meant to work with them. We're really meant as lawyers to enable an attorney-client relationship wherever it is possible. And I think because I do so much guardianship work and see what capacity looks like and what incapacity looks like and where the judges are, I feel really confident presuming capacity and keeping people out of court to the extent possible. And so you want to work with someone who's just comfortable and willing to take a little bit of risk, you know, someone who's like, oh, I don't know. Like, no, like, we get to presume capacity. That's like our motto at our firm. And we're really trying to break it down into its simplest component parts. Do you trust this person? Let's name them then. You know, would you trust them to make any decision for your health? Yes, great. They're now your healthcare proxy. You know, so that's what we can do with someone who is on a higher, you know, functioning spectrum.
There's also a big push in New York for the supported decision making. So there's a lot of session, like webinars and stuff on that lately.
Okay.
Also, because they're trying to, well, you'll talk about the different kinds of guardianship, but the supported decision making is exactly what you're saying, is can the person make some of their own decisions and to what extent?
Yeah, and I talked before about not funding an SMT until the child turns 21. So that's the age marker for the trust world. For this world, your age marker is 18, because as a parent, you lose authority when the child turns 18, and that's when they're their own legal person. But if they don't have legal capacity, that's when you need to come in as a court-appointed legal guardian of some kind. And I think some of the supported decision-making conversation is about having more of a co-participation than just the parents now in charge of everything for life. And I'll talk a little bit about that debate when we get to that guardianship statute. Okay, so the first thing we're trying to do is have the child do their own legal documents. And that again requires nature and consequences and understanding it. So that's our first choice. Our second choice is the Surrogate Court Procedure Act, Article 17A guardianship. That's because our clients can largely do this pro se. And if even if they hire us to do it, it's a much more economical legal engagement than the third choice, which is a mental hygiene law, Article 81, adult guardianship court proceeding. So if you think of the pendulum, so 17A is considered to be this whole, let's make things easy for the parents. Article 81 is about, let's do a narrowly tailored guardianship court order that really preserves the rights of the person who presents with disabilities and needs assistance with activities of daily living. And that sounds great, right? But Article 81 is trial work, and it has a lot more ongoing court supervision than Article 17A. And so this last year, because there has been constitutional litigation even over the validity of 17A, we've tried on some of our cases where the child was, it's more a mental health issue with some oppositional defiance. We brought in an 81, feeling really ethical in doing it. The court looked at us sideways for why are we even bringing this as an 81 proceeding? And ultimately we got an 81 guardian. The parent was named an Article 81 guardian with full authority to do everything for the child. There were a few incidents during the course of the proceeding which I think persuaded the court to give full authority to the parent. But that said, if I could do it all over again, I would have brought that one in 17A and seen if we could snuck through, because it did end up being really expensive. Okay, so 17A is governed by surrogates court. 81 is governed by our trial court called Supreme Court in New York State. Our lowest trial court is called Supreme Court, which is odd. And it's really meant to be super accessible to parents. But there is a supposed finality to it. That said, you can always undo a 17A guardianship. So it's not, nothing is ever undoable. The onset of the presenting intellectual developmental disability has to be prior to the age of 22. Doesn't mean that you have to bring the proceeding before that age, but you have to show evidence that the issues surfaced before the age of 22. And if you think of some mental health issues, that there might be, first episode in your mid-20s or whatnot, so that type of situation would require an 81 proceeding. That said, I've brought proceedings for people in 17A who are 58 years old. Not so easy to get medical records from when they were under 22. So always better to address guardianship sooner while the records are fresh and the doctors are able to submit affidavits. And that's a huge difference between 17A and 81. 17A is based on doctors' affidavits. 81, that's not even admissible. You can't violate someone's medical right of privilege when you bring an 81 proceeding. You have to adduce facts showing that they need support with activities of daily living. So it's very much a functional limitation test rather than a diagnosis-based decision. We're really making strides in our surrogates court with turnaround times. With that said, you want to give yourself some lead time with when you bring a 17A proceeding. So I wouldn't wait till the child's 18th birthday. I'd start the conversations with the lawyer around age 16 to 17 so we could get in the system and have the transition be seamless. You also have to get statements from the county that there's never been a child protective service proceeding against you. So those are some things that can slow it down. A guardian ad litem is appointed in the 17A proceeding. An attorney like me who just calls the doctors, makes sure they sign the affidavit and that the affidavits weren't forged. We meet with the parents, we meet with the child, we issue a written report to the court. It all happens typically without a hearing and commonly without the judge even meeting the child. And that fundamentally is why it was challenged in federal court. It was thrown out, the challenge, by federal court. They deferred to the state legislature. But there are some third-party nonprofits intervening in proceedings. There are definitely, surrogates court records are open to the public, and so they are monitoring the 17A filings. And then that's where letters of guardianship issue. So that's what adduces your authority at the end, are these letters from the surrogates court judge. And you have to file this written statement every year, but it's a pretty easy statement. Has anyone ever had to file this statement?
I don't think they do this anymore, the property one.
Okay.
I just heard that, because I've never had to do that.
Okay. There are certain property that you don't have to do it for, like Social Security income.
Maybe that's what it is.
But if there's other property, there's generally an annual filing requirement. It's pretty straightforward. And I talked about the criticism. Okay. All right, so Article 81 is most commonly used for people who had capacity and then at some point lost it, but never signed advance directives. So Article 81 guardianship is meant to be the least restrictive alternative. So if you have advance directives and it gives you all the authority that you need, even if a person needed support with their activities of daily living, you're still not going to get a guardian because you have advance directives. Or you're going to get a very limited guardianship. If there's some one little thing the advance directives don't allow for, they're going to let you do that one little thing. What makes it expensive is that everything it looks like the court is doing, we're actually doing for the court. So guardianships in 81 are commenced with an order to show cause signed by a judge. Well, that order to show cause is prepared by a private lawyer with a petition signed by the client. So we work with the client to develop the petition that then leads to the signing of the order to show cause, and then a hearing has to legally take place within 28 days of the signing of the order to show cause. So it's all fast-tracked. It's meant to be this emergency relief. You're essentially swearing in your petition that the person not only needs support, but is in imminent risk of harm, not having a guardian. And it's that imminent nature of it that fast-tracks it. So you have the order to show cause. That order to show cause appoints other lawyers too, which is why it gets expensive. There's going to be a lawyer appointed for the alleged incapacitated person, the AIP. And then if it looks like it's going to be contested, or depending on the jurisdiction, there's going to be a court evaluator. So some judges, like Manhattan, they always appoint a court evaluator, sometimes appoint an attorney for the AIP. Westchester's the opposite. Always appoint an attorney for the AIP, sometimes also appoint a court evaluator. Then we have a hearing. We often get a verbal order of guardianship at the hearing. That has to then be settled in a written order. And then once the written order isn't objected to, that's when you have to serve the notice of entry. So it's like there's 4 different layers of paperwork here. And then a commission issues. So when you're a 17A guardian, you get letters. When you're an Article 81 guardian, you get a commission. And then reports are due annually, and they're reviewed by a lawyer. So you have to pay the lawyer, the private lawyer, to review your reports. They're going to ask you for supplemental information, and you have to document it to the penny. And it's frustrating because if we're working with a client and there's a missing dollar, they're paying us, $3.50 an hour to find the missing dollar, and it doesn't matter. You have to find the missing dollar for the court examiner. So it can be a frustrating rubric to be under, believe me. And so then this brings us to ABLE accounts as a planning option for certain families, but not all. The most a beneficiary can have access to in an ABLE account is $100,000. So if you think about what your life insurance policies are, your retirement accounts, your equity in your home, like an ABLE account as a trust substitute isn't going to be that meaningful an option. But for certain families who all they have is $50,000, and if they could avoid the expense of creating a trust and the ongoing management of it by creating an ABLE account, it's just an amazing option now. And what's nice about an ABLE account money can be used and spent a little bit more freely than pooled trust account money. So that's where I like it, because it doesn't result in the SSI income disregards. And so that's where I see it as like a planning option for families. And it has to be spent on a qualified disability expense, but you can see from the list of qualified disability expenses that it's everything that people need in life. It's housing, transportation, education, training, assistive technology, health, funeral and burial expenses. So that's not a curtailing requirement. Again, you have this issue of how are you eligible for it, and here they have the age marker of 26 as one of the requirements, overall here. So we have 18, we have 21, we have 22, we have 26. Like, you're throwing all these different numbers, and some of them are going to apply in some settings and not others. And it can be opened by the beneficiary himself or herself if that person has legal capacity, or a parent or legal guardian, or an agent under a power of attorney. But again, they need legal capacity to be able to sign a power of attorney. And then anyone can contribute. So only certain people can open the account, and then anyone can put money into it. And only one account per beneficiary, and maximum amount per year is $15,000. All right, and again, we go back to that payback to the state for anything that's left upon death. So that's something, in some respects, it's good that people can't put more than $100,000 in there, because if they didn't know about that payback requirement, a third-party trust would be a much better option. Okay. I talked for a long time. You guys are a really patient audience. Just know that like this is the medley of programs. And if you guys ever want a follow-up lecture, whether even by me or someone else in the community that's like much more program specific, I think the more information you can get about housing, the sooner that can be its own kind of brainstorming, collaborative session. And I would actually love to hear what some of the options are. You know, I think it is much more discussion-based housing. But any questions? You guys were good about asking as we went along. Thank you for having me.
Thank you.
Or there's a whole bunch of stuff on the SSI and Medicaid and all that kind of stuff. I missed some of your thing. Guy in Ray Sedalis, have you heard of him? Who does a whole thing on how an individual can work and still maintain some of the benefits. And he does it. He's like the guru in New York.
What's his name?
Ray Sabella.
Okay.
And about how it's really confusing, and I really can't say I understand it completely, but you know, there's like, if you make a certain amount of money, you lose some benefits.
Yeah.
But he goes over like how you actually can maximize everything, and you can pay into Medicaid because, but it's something like $25 a year. So if that's your most important thing, and you're generating enough income that's a problem, $25 a year, you know, so it really gets up to being something like $45,000 a year of income before you really start bumping into some of this, these issues. I can't explain it better than that because it's very confusing, but I want people to know that that's out there, because if your child is working and making income and you're worried about that, know that there are benefit eligibility experts that can help you navigate through some of that. So.
No, that's amazing. And in general, and it's for better or worse, there are a lot of social workers in this space. So just make sure that the trust documents, the legal planning is done at the lawyer level. And then get a recommendation from a lawyer if you're going to use a non-lawyer for any other additional work, because there are some people who are developing Medicaid plans without considering the recovery part of it. So they're getting someone eligible, but then they're not protecting the money upon that person's death. And so there's just like in any field, there's good actors and bad out there. Be a little careful.